Welcome to the Court of Appeals. We have one matter on oral argument for this morning. It's Stephensen versus Stephensen. And counsel could state their appearances, please.
Julie Nelson for appellant Carrie Stephensen.
Kristen Kibberts for appellee Shauna Stephensen.
Great. You're both very familiar with how things work here, unless you have any questions. I see that we have 10 minutes on the clock, meaning you're reserving 5.
Correct.
Seeing no questions, you may proceed.
Thank you. May it please the court, Julie Nelson for appellant Carrie Stephensen. This case should be a straight shot. Carrie maintained the marital estate. Shauna didn't. Carrie paid for expenses, taxes, insurance, repairs. Shauna didn't. Carrie should have been compensated for that. He wasn't. The reason he wasn't was not because the trial court said that the expenses were invalid or that they were not marital. It was because the trial court fundamentally misunderstood Utah law on property distribution. Now, there is such a thing in Utah law as separate property. Inheritance, gifts, premarital property, definitely. That is not this case. This is marital money. To allow the parties to go forward, this was a pretty long pendency of the divorce, and to allow the parties to go forward, they had bank accounts and they were given a monthly allowance.
Can I ask you just on kind of a 30,000-foot view, you indicate that in the beginning of your brief that the district court has considerable discretion in arranging such financial matters. Where does that discretion end, and how would you couch that? Do you understand my question?
I absolutely do. In the standard of review section of our brief, it does say that there's considerable discretion, but it also says that there's an abuse of discretion if the trial court misunderstood or misapplied the law. And that's where I am today. The trial court misapplied the law because you had marital money. Carrie's half was burdened. Shauna's half was not burdened. And
yeah, so this is a factually complicated case. So I want to make sure that I understand sort of what happened here. I think I understand your argument about Carrie's half and Shauna's half as it concerns the KMK expenses. After the here we go ruling, as you put it,
right.
$7,500 went to Shauna and $7,500 went to Carrie, and there
Right.
wasn't anything left over of the KMK revenue to pay KMK expenses, and whatever expenses there were, presumably this is triple net lease at this point, so they probably weren't much, but Carrie had to pay them out of his half because that had already been halved and given.
Exactly.
I think I follow that argument, and we'll come back to some of the questions I have about that argument later. But with regard to the Bell Canyon, I don't follow the argument, and so I'm going to need some help from you this morning to figure that out.
Okay.
Because with regard to the Bell Canyon expenses, they weren't paid out of something that had already been halved.
Well,
They were paid out of Monex, right?
yes.
And Monex got put entirely into Carrie's personal account. And that was the locus or the source of the funds from which those were paid. It hadn't ever been halved. He took the whole thing and put it in his personal account, right?
Yes, but
So this distinction I'm making between those two, and then I'll let you talk, is that one of them gets halved and he pays out of his half. The other one, the whole thing goes in and he pays out of that. And it seems like there's a fundamental difference there between the argument you're making. I follow the argument with regard to the thing that's already been halved. I don't follow it with regard to the whole thing. Does that make sense?
it does. So I'm going to focus on Bell Canyon.
Okay.
All right. So with the Bell Canyon property, yes, he paid it out of the Monex money, but the party's marital, everything, there was some tiny amount of premarital and that was taken out, and we're not talking about that. So everything else was considered marital, and everybody's supposed to get 50% of that. The Monex was on Carrie's side, but ultimately there was a reconciliation done to make sure that everybody had the same amount. However, that reconciliation didn't account for the fact that the trial court found that the Bell Canyon expenses were like $172,000. The trial court had a number that was attributed to finishing Bell Canyon, and Shauna benefited from those improvements in Bell Canyon.
So the trial court's ruling on that was, I don't care what the number is, because those expenses were paid out of this marital corpus that came over from Monex. And that makes sense to me. I guess I need you to tell me why the trial court was wrong on that point, because again, that thing hadn't already been halved. And if those expenses are being paid out of this marital corpus that came over from Monex, it doesn't really matter whether that's trued up before or after. because people just get half of it, right?
No, it does matter if it's trued up before
So
or after.
that's what I'm not following.
Yeah, okay, it's an order of operations question, absolutely. So if you take, like, you've got X, here's the entire marital thing, and you take out the expenses off the top, and then you divide in half, everybody gets the same amount of money. But if you divide in half and then only take the expenses out of one person's side, people don't end up with the same number.
Yeah, but see,
at
that's
the
where you
bottom.
lose me. Taking it out of one person's side, there isn't a side here because the whole thing goes over en masse.
No, but there.
That's where you're losing me.
Okay,
Help me
but there is
understand
there is a side, because first off, they both got bank accounts to work with. And then when the trial court puts the ruling together, it calculates out like what those amounts were and divided it. Like, when we look at the ruling, we've got everybody's getting the same amount, except that we're not accounting for the fact that Carrie actually spent $172,000 of that to service the marital estate.
Okay, so let's say hypothetically that Monix had been left Monix and it hadn't been, I don't want to use the word commingled, that's a whole little minefield there.
Right.
But let's say that Monix had been left Monix and Carrie had controlled Monix. He hadn't dumped it into his personal account, but he controls both accounts and he just pays them the expenses out of Monix as he goes.
Right.
Does it matter in that instance whether you value it in the beginning or value it at the end?
Yes, if you value it such that only one person, that they get equal amounts in the end, not accounting for the fact, I'm sorry, they got equal amounts at the beginning, and somebody has to keep paying for that. So it's not true.
Right, but if the expenses are coming out of that, like if you divide it in the beginning, there's like 198,000 in there, right?
Right.
So they get 99,000 each. And if you divide it at the end after the 172 is gone, there's what, 26 left in there. They each get 13. So whether you divide it at the end or whether you divide it at the beginning, it seems like it comes out in the wash.
But I don't think that's what happened. I think that when we look at the ruling, and we go to page 2457, the full amount of Monix is on petitioner's side. She gets $98,792.25 credit. So in theory, Carrie also gets $98,792.25 credit, except that he didn't, because that money wasn't actually there, right? He had taken the Monix money on the front end, spent it on the house, but then that full amount was still what was divided.
Let me make
So-
sure I'm looking at the right thing. When you say she got 24, point me to where you're looking at.
Okay, I'm on 2457.
Okay.
The fourth line down, one half of Monix.
Yeah, so this is my question. So she gets 98,792 out of Monix and so does he, right?
Well, but only in theory. Because,
But hers is theoretical too, because this is, whether those two line items are both 98 or whether they're both 13, it doesn't seem to matter because it's equal both scenarios.
yes, but,
What's wrong about that?
okay. What's wrong about it is that she got the 98,792 and he actually got zero because or 13 or, some small amount, because he actually only got his share minus what had already been spent, but she got credited for her full share as if none had been spent. And so the 98,000 versus 13,000 makes a big difference when you get into the subtotal due to petitioner. That's the amount that she ends up getting, 821, out of the Bell Canyon proceeds. It doesn't account for the fact that some of the Bell Canyon money had been spent. There should be a line item saying that she's responsible for half of those expenses. So she shouldn't actually be getting credit for $98,792, because as you pointed
But
out,
neither should he, and he's getting that credit too.
no, he
He is in the calculation, right? If you flip over the page,
It's the same figure.
he's got the same line item. It's the second line item on page 2458.
yeah, that's true. But
Okay, so they're both getting the same amount, whether it's 98 or whether it's 13, it seems like that washes. That's where you're losing me.
all right, so our problem is that when we go back to page 2444, you've got a factual finding that says the court finds that the value of the account as of the date of separation was $197,000 and will be the value of the marital asset subject to allocation and adjustment for Bell Canyon expenses and personal use, right? It says it's going to make that adjustment. And then later on, it tells you what the amount is, that it's 172,000, but it doesn't make that adjustment. Now, your point is that it doesn't matter because it's just turning out to be 13,000.
Well, my point is that those expenses were paid out of the Monix corpus. Now, whether the Monix corpus remains separate or whether the Monix corpus is transferred into his personal account, my head hurts to try to figure out why that matters, right? If the Monix corpus is the source of those funds, then it's coming out of the marital account, and it doesn't really matter, I don't think, whether it gets valued in the beginning or valued at the end. That's the problem I'm having.
All right, I have like a couple seconds left.
Keep going.
Can I talk about KMK?
And ask him.
All right, so in the KMK, Kerry's ordered to maintain the KMK property. He's ordered to pay it at 486 and at 227. We go to the here we go ruling. Trial court says, no, I don't care. Everybody gets the same amount of money. Kerry comes to trial. He presents his receipts. Like, I've never literally seen all these receipts come in. The trial court has credit card statements. Those are cross-referenced with receipts. It's got all this testimony. It's explaining what it means to have a loan to the property.
Are we talking about the KMK expenses now or the Bell Canyon expenses?
What?
Did you switch topics on me?
Yes.
Yes.
Okay.
Yes.
Sure, I follow.
Yes. But I did say, can I talk about KMK first?
Totally. I just want to
In
make
my
sure that what we're talking about now is the KMK expenses. Okay.
In my defense. So he comes to trial, he's asking for a true-up, he's asking for a reconciliation. We do that all the time in family law. And the trial court just says, no, because it's marital money. But that was different because Kerry's half was burdened, Shauna's half was not burdened.
The KMK expenses, it felt to me like the trial court was handling that a little bit differently. So the trial court actually gave $11,000 of KMK expenses for something, I can't remember exactly what, right? So the trial court seems to be acknowledging that Kerry would be entitled to true up for the KMK expenses after the here we go ruling, because the trial court gives him $11,000. But the trial court's ruling on the KMK expenses seemed to be more granular than that. It seemed to be the trial court seemed to be sort of shooting down each one of Kerry's claimed expenses for failure of proof. The 5%, was it a commission or something, and the salary he wanted, and all these other things, he shoots these things down, not because of, not because, I don't think Judge Skanke thought Kerry wasn't entitled to a true-up on those things. It looked to me like it was more of a failure of proof ruling. Did I read that wrong?
I agree with that to an extent. The $11,500 was a management fee that they had agreed on. You're right, the trial court gave him credit for that. There were other claims that Kerry had made, like, for example, he wanted to be compensated for the work that he had done, and the trial court said no, and we didn't appeal that. All we're appealing is like the actual hard expenses.
Yeah, like what? And that's, from your brief, I couldn't really pull those out. The ones that really got talked about in the brief were these 5% management fee and the $108,000 salary and these sort of bigger ticket items that the trial court talked about in the ruling and had specific reasons for shooting them down. Are you talking about expenses other than that?
Yes, so on page 26 of our brief.
26?
Uh-huh.
Okay, is this the paragraph with insurance of 7,000?
Exactly. Those types of expenses, that's all we're appealing. I understand there were other things that the trial court knocked out, and we haven't appealed that because we determined that, well, that was probably inside the trial court's discretion. But when you're actually talking about hard expenses, and the trial court at several places, at 2444, 2446, 2447, 2448, talked about there would be subject to offsets later set forth.
Okay, do you have a list of these other than these three that you mentioned on page 26?
Well, so on a remand, because the trial court was bugged because Kerry had included a lot of things that the trial court eliminated, but the trial court never actually eliminated the hard expenses like the insurance and the fees and things like that because ultimately the trial court knocked that out because it was paid with marital money. That was wrong. The trial court should have given credit for that. On remand, the trial court's gonna have to go through, and I would think that what would happen on remand is that a list is going to have to be created from the exhibits that were created at trial, segregating all the things that have been eliminated and saying, okay, here are the expenses that are left over. And the trial,
exactly. So segregating all the things the trial court's already made a ruling on that you now say you're not appealing. I was confused about that too. It looked like you were appealing the trial court's decision with regard to those other, the 5% and the salary and all those other
No.
things. You're not.
We're not appealing that.
Okay, so
So we tried to
So-
clarify that.
What would the remand order look like then, that you're asking us to put in place?
A remand order would look like the trial court, Carrie should be compensated for legitimate marital expenses, such as,
Well, legitimate KMK expenses post
Fine.
the here we go ruling.
fine, that's fine.
But the trial court already eliminated a bunch of those.
Yeah.
And
But
if
it
you're
never
not appealing
eliminated-
those, you can't go back and unpack that on remand. If you haven't appealed them now, that would be the mandate rule and all that law.
Absolutely.
Okay.
No, that's absolutely right. That's absolutely right. And it would be down to the hard expenses, like, I mean, I don't know if hard expenses is the technical term, but like actually an amount of money that he had to front for insurance, for taxes, for things like that. And
Well,
So
it's the things like that part that makes me nervous. Like, if we don't know what those are in your briefing now, other than these three, it seems, I just get this hinky feeling about sending it back for some sort of,
It
freewheeling
almost
inquiry.
feels like you're in that regard attacking the factual findings as being insufficient.
well, I'm not trying to attack the factual findings as being
Do you
insufficient.
see what I'm saying? That there's a space in between, yeah, the court got granular on these things and we're not appealing them. And here we've identified three things that the court didn't grapple with, but there's others. I can follow the three things you're saying it didn't grapple with, but it seems like if you're saying there's some things in between those that remain unidentified, that's a failure of adequate findings, not a legal mistake, right?
Well, I don't think so. So let's look at the ruling. So I'm starting on, KMK starts on page 2452. 2453 has the KMK management fee, that was given credit for. Negotiation of lease extension, we're not talking about, there's nothing in there relevant to the appeal. 3, claim for a salary to manage KMK, that was rejected, we haven't appealed that. Unpaid portion of KMK rental income, that's another issue that's its own issue.
Yeah, we'll get to that in a minute.
Okay, KMK rental proceeds. That's Romanet 5. Hold that thought. When we go to Romanet 6, personal expenses paid to respondent from KMK, the trial court knocked that out and we didn't appeal that. So we're only looking at Romanet 5. And the trial court acknowledges that the respondent provides in Exhibit 90 a statement of income, which purports to be the income and expenses. It lists these things. It says, adding these fees back, I'm on the first full paragraph on 2455. Adding these fees back into the and there should be net income results in blah, 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 reduces the expenses to $171,003.71. So the trial court can do it. It comes up with an actual number. But then it says the trial court is left with a net rental income for KMK of petitioner's claim and an adjusted respondent's claim. Other than as set forth in subparagraph 4, the parties had negotiated and stipulated to a division of the rental income as it came in, and the court will not make any adjustment. That is not true.
Well, it's true prior to this here we go.
Agree, but it is not true
It's not
after
true
the here we
after.
go ruling.
Isn't that how you answer Judge Mortensen's question then, is you say that once we would say, it's sort of in response to both your questions, that if we would say that when the court talks about stipulation, that's wrong, that's like the fundamental error that then infects the rest going backwards of everything that it said.
Exactly right. There was no stipulation on that point. Had there been, then sure, we would, we might not be here. But there was not. There was a trial court order, and it was heavily contested at the hearing that was not going to work.
Then just teasing this out, if we were to write the decision saying that the court's, this portion of the court's ruling is wrong because it sort of starts from the wrong, sort of ends from the wrong place, the stipulation place, would we then be sending it back to the district court to figure out the impact of that improper stipulation
Exactly.
thing?
That's exactly right.
Which in theory could reach beyond the three that were talked about on page 20.
Sure, I mean, the trial court was able to come up with a list. Its list added up to $171,003.71. The trial court's just gonna have to figure out how much of that came after the November ruling. And I suppose it's possible that, I haven't done this math, I suppose it's possible that before that, not all of the expenses were covered by that amount. I mean, that would have to be part of it too, but We're not trying to sneak in the salary and the personal expenses and all of those things. I'm just looking right here at this Romanet 5 and that sentence. They had negotiated and stipulated to a division. The court will not make any adjustment. That's the part that,
No, I get that. I guess
Is unfair.
where I'm a little bit puzzled is that we don't have anywhere in the briefing a sort of a list of which expenses those are.
that's because I figured that was a remand issue. I mean, we just need a remand to say you need to go back and figure out exactly what those expenses are. And we can do it. All the information is in the record. You've got Exhibit 90, Exhibit 95, those kinds of things.
Okay, so the remand would look like something like this. You go back, trial court, and figure out, post here we go ruling, which expenses Kerry can actually prove he spent his half of the money on,
Sure.
something like that.
Yeah. And it's not really a failure of proof issue because there's all those receipts, there's all those QuickBooks.
Well, it may or may not be, but that's for the trial court to tell us. I mean,
Exactly.
the trial court seemed to think there was a failure of proof issue on the salary and on these other things that you've not appealed.
Correct.
And if the trial court were to make that ruling again, then that would be tough for you to come appeal again, right? Because
And I would
it's-
not. I mean, I'm not expecting
Those
that
are-
to be part of the remand.
Yeah,
Did you want to talk about the,
yes, briefly.
Make sure we're talking about the right thing. We want to talk about the what?
Issue number 3.
Got it,
the,
okay.
the-
Same page.
The unpaid distributions.
Yes.
So, it seems like there's 2 issues here that are under this. There's whether there was an extra missing payment in 2020 at the end of June, right?
2020 at the end of June?
Am I right about that? That's the issue in 2020, right?
No.
Whether there was a June 30th payment that counted for July?
Yes.
And then in 2021, the issue is whether there was a payment made on March 1st.
Correct.
Those are two separate issues.
That's right. And so I would ask for a remand that said that it's undisputed, the July was obviously paid in June. So that's an error. And that the trial court's gonna have to make a factual finding on whether the March 2021 check was paid. I mean, I have
Didn't the-
been through,
Didn't the court make an implied finding on that second part? There was conflicting evidence on that point. Shauna said, I didn't get the payment. Carrie said, yeah, I gave you the payment. And the court made a ruling, you didn't really explain it, but the ruling was that payment didn't get made.
well, I mean, if that's the way we look at it, then I would say it conflicts with the evidence because Respondent's Exhibit 97, page 2 shows that it was paid. However, I see your point. But there's really no way around the July, June payment
Yeah,
issue.
the July-June one, do we really need a remand on that if we go back?
You
and
could
look-
just fix it.
If we look back
Yep.
at the underlying documents,
Right.
including both sides' exhibits, if
Yes.
we see that there was just a mistake there, we could just fix it.
I think you could just fix that. Yes. All right, thank you.
Since you're answering our questions, we'll give you your full rebuttal.
May it please the court and counsel, Kristen Keberts, on behalf of appellee. Appellant is asking this court for an offset for what he himself has framed to the trial court as a personal loan from the Monex account, or his half of the marital plot to pay for marital expenses. Offsets are not presumed. They have to be proved with reliable proof. And once those Monex dollars went into the KMK account, they lost their identity. The QuickBook accounting was not reliable proof, and the trial court was right to deny his claim.
What does that mean, they lost their identity? If they start out as marital funds, if they lose their identity, what did they become? I'm not sure I'm following that.
The problem was, and I just kind of want to give some framework, how they lost their identity in terms of,
They'll lose their identity from what to what?
and I think that's the problem with the framework of how this is set up and how Kerry is trying to prove his entitlement to an offset. He's trying to say, I used my half of the marital pot to pay for marital expenses. So the question is, to prove his offset claim, he has to do one of two things. So he has to prove that he used his own separate money to pay for those marital expenses, which he can't do. The trial court said that, transferring it from this pot into a marital pot.
I mean, I guess that feels to me like the disconnect between the two briefing. I mean, you've framed it as an identity question, you've invoked principles of commingling in the brief. And the other side's point is this isn't a commingling problem at all, this is not an identity problem, it's a math problem. And maybe the math problem goes one way, maybe it goes the other way, but it's a math problem, it's not an identity problem. And what they're telling us on the identity question, as I understand, if I'm tracking all this right, is if the trial court thinks it was, the Monex money was marital to begin with, and if the trial court thinks that the Bell Canyon expenses were marital expenses, then yes, we do have this complicated math problem in the middle, but it's not an identity problem because it was marital at the beginning and it was marital at the end. So I guess that's my question. Is that right, that it was marital at the beginning and it was marital at the end?
Yes, they're both marital pots, I guess.
So then it's not an identity problem, it's just a problem of figuring out the expenses on the back end and figuring out who gets what, right?
It does become an identity problem.
Tell me why, because that's what I'm not
There's one
following.
of two ways to prove that he used his half of the pot to pay for Monex expenses. The one way is the one I
Or
told
Bell
you.
Canyon expenses.
Sorry, Bell Canyon expenses. The one is if it was totally his separate money and then it was put to marital expenses. The other way is if he could show dollar for dollar, everything that was transferred for the Monex account was used for Bell Canyon. Or at least, 175,000 or whatever the amount was.
The problem I'm having with the his half argument is that Monex was never halved. He took the whole thing and he put it in his personal account.
Right. And
So I don't understand why we're even talking about his half. He took a big pot of marital money and basically took it. I mean,
Essentially,
the court told him he could control it, that's fine, but he made the choice to take it out of the Monex account and put it in his personal account and mix this all together. But nothing was ever halved.
Right, it's just a paper half. It's just, an IOU. It's the way the court separated it.
But why do we need to separate? This goes to Judge Tenney's question, right? If we take the corpus of Monex and we put it inside this other personal account, Monex is still in there. It's still living.
We know how much Monex was.
Right.
Right.
And on the back end, we can find out in theory how much he spent on Bell Canyon. And so if this part was marital and this part is marital, why do we have to futz around with the middle? Why aren't we just looking at the back end of this and saying, how much did you spend on Bell Canyon and what does that do to the marital estate?
Well, I mean, why you don't just focus on Bell Canyon is, or why the trial court didn't, just half Bell Canyon is because of his argument. He's claiming or give him an offset for it. He's claiming I used my half of the pot to pay for Bell Canyon. So
Yeah, I mean, what's a little bit weird to
But
me
he
about
didn't.
this,
He
and
used
maybe
the
this,
whole pot.
yeah, maybe this is a question.
Right. Well, I mean, it's a theoretical. It's an IOU. It's just the way it was framed at trial. It was we're separating the Monex account at separation, but the KMK account wasn't valued until the time of trial. It was a going concern, so it had revenues and other things. So the problem is with their argument is if they're going to be claiming, I used my half of the account to pay for this Bell Canyon expense, they have to show that they used his half of the pot, and they can't do it. One, because it's marital money moving into a marital account, and two, they can't.
But I think that's their point. Their point is that the whole pot was a marital pot to begin with. And so if you deduct the expenses, the Bell Canyon expenses from the marital pot, the division should happen. This is what Ms. Nelson refers to as the order of operations problem. She's saying you're supposed to have done that deduction first, and then whatever's left, that's the moment where you half it. I think that's the argument on the other side. Why is that wrong?
It's because of the way it was valued, and both the KMK and the Monex account. With the Monex being valued at separation, and the KMK account being an ongoing concern with revenues and expenses being paid throughout, there's a concern that KMK is paying for those Bell Canyon expenses, and that was the concern, that bringing it into that account, and actually KMK is paying for those expenses, not the Monex account. And that's the problem of proof that the trial court was struggling with. You have to prove that your half of that account was used to pay for
But
marital.
I just don't see why that's a problem of proof. I mean, again, I'm back to sort of my base question, and maybe I'm just not seeing it. Math's not my strong suit always. But if you can figure out the value of Monex at the beginning,
Right.
and if you can then figure out how much he spends on Bell Canyon, and if we're all agreeing, and correct me if I'm wrong, but I think we're all agreeing that the Bell Canyon expenses are a marital expense. We just stop there. Are we all agreeing on that?
Yes.
Okay, so if we know the value of Monex at the beginning, and if we can figure out with receipts what he spends on Bell Canyon, and that's a marital expense, why isn't it as simple as we deduct that, we deduct the Bell Canyon marital expenses from the value of Monex, and then we half that? Why is that not?
Well, if
It would
we'd
become-
done that, let me take a
Sorry,
crack at
sorry.
answering Judge Tenney's question.
Yeah.
If we'd done that, we'd get the 13 on each side. We would take the 198, we'd subtract the 172, and we'd get 26.
Right.
And we'd divide the 26 and give each side 13. And so those lines that Ms. Nelson was pointing out in those tables wouldn't say 98, 792 each. They'd say 13 something something each. But my question was, as long as they're the same, what difference does it make? And that's what Judge Skanke ultimately determined, is we don't need to value those costs because those costs came out of a big marital corpus anyway.
Right.
And shrug,
Right.
right? And
Right,
so
I mean, if you-
that's the problem I was
If you
having.
do it the other way, where we value it half, then the concern is that we'd have the other problem where Carrie would be getting an unfair equitable share.
Explain that to me. I think I follow that, but I want to hear it to make sure I've got it right.
Well,
Tell me why that creates that problem.
I hate doing math, but I'll do my best.
Oh, you're deep in.
I'm deep in.
You might be preaching to the choir.
And
guys
I
bring-
mean,
you
I
guys
kind
brought
of
us a math
already,
problem. You
I
gotta help
kind
us
of
solve
already
it.
did this math problem in the brief. But we're talking about, the marital money from the Monex account. So say it's $1,000, and it goes into KMK. So if we're
So
thinking,
is KMK and his personal account the same thing?
it is, he treated the business operating account as his own, personal.
I thought there was 3 different accounts, Monex, the KMK account, and then his Chase account. Am I wrong about that?
No, this is money going into the KMK account. So he's using the KMK operating account to pay for his personal expenses, to pay for KMK expenses, and to
Well, that may
pay
or may
for
not have been
healthcare.
true, but it could still be true that there's separate accounts, right? And that's, I guess, maybe Ms. Nelson can help clarify that, but I thought there was 2 different accounts, and that Monex corpus didn't go into the KMK corporate account, it went into his personal Chase account.
I think originally it may have moved into his Chase account, and then it was transferred into the KMK account. But eventually it ended up in the KMK account, and so the KMK operation account is what's paying for Bell Canyon. And in addition to paying for KMK and also Carrie's personal expenses. And that's where the court had the problem, because how do we show that KMK isn't paying for Bell Canyon versus the money from Monex paying for KMK? And that's what the trial court was grappling with. And it was a matter of proof, because I transferred the money over here, hence it must be, to pay for KMK or pay for Bell Canyon. And the court's like, you can't do that when we also have KMK revenues coming out of this, or KMK revenues coming into this. We also have KMK expenses coming out of this. Doesn't trust the accountant because he's, telling him what's Bell Canyon expenses, telling him what's KMK expenses, and what his personal expenses are. There's a real problem figuring and untangling what came from Monex.
Okay.
And that's part of the problem. So it is kind of a tracing problem as well.
Can I move you on to the KMK expenses, which I think we made some progress, at least I got a better understanding of what their argument is with Ms. Nelson's time at the podium. So they're not appealing the $108,000 salary, they're not appealing the management fee, they're not appealing some of these personal expenses. What they are appealing, apparently, is Romanet 5, KMK rental proceeds as exemplified by the expenses that appear on page 26 of the blue brief. Insurance of $7,000, building insurance of $8,000, a bond with Sandy City for $3,800, for instance. On that topic, it looks like there was some sort of stipulation at some point from your side, as exemplified by this $11,000 fee thing that the court gave Carrie credit for. It seems like there was a stipulated agreement at some point from your side that Carrie actually would be entitled to reimbursement for KMK expenses after the Here We Go ruling that he paid out of his half. Is that right? Do I understand that you guys sort of had that understanding?
The KMK expenses would be determined after
Yeah, assuming he can prove he paid them and all that. Assuming we don't have a failure of proof problem, it seems like there was an understanding, at least at one point, that he'd be able to come in and show that, yeah, after the Here We Go ruling, after nothing was extra left over put into an account to pay these expenses, if he paid them out of his half, then he'd get a true up for that.
Right, an offset if he did that. And I think the court had, it again became a problem of proof because of the,
Yeah,
the accounting.
And so I get that the court is rejecting a bunch of these on failure of proof grounds, and Ms. Nelson clarified that she's not appealing those. So this second issue kind of got narrowed today in my own mind, down to these other things that were discussed sort of obliquely in Romanet 5. And the court here sort of disposes of this by saying, well, the parties negotiated and stipulated to it, so I'm not going to fuss with it. And what Ms. Nelson would like us to do is remand just for consideration of these. She'd like to have us say, yes, Carrie should be entitled to these, assuming he can prove them, so on remand, we want you to take another go at this. Why shouldn't we do that?
I mean, the problem, again, is a problem of proof. The court had already found that he was really struggling with Carrie's labeling of these different expenses. And so if we just go back down, we're gonna have the same struggles again.
Well, maybe, but if the court had said in Romanet 5, look, these insurance and building costs and these bonds, if the court had said here in Romanet 5, look, I don't think these things have been proven, I find by a preponderance that they haven't been proven, we'd be in a different situation. I don't see that the court's saying that here. If the court's saying that in Romanet 5, maybe you can point it out to me, but I think the court seems to be making this decision on a different basis, no?
No, the way I read the court's decision is he was going to base it off of the 2019 stipulation, and that the distributions would be split as they come in, and then they would leave a pot for KMK expenses.
Right, and that worked great up until the Here We Go ruling, when there was no pot left over. So what do we do
I
with
mean,
the time period after
theoretically-
that?
Theoretically, there was no pot left over, but I mean, that's not in reality how it happened on the groundwork. It wasn't like Shauna actually received any of her distributions during that time frame. I mean, if we were going to be talking about that pot, it would have been under the 2019 stipulation, would have been about $51,000. Shauna was undisputably not paid $52,000 and still hasn't been paid that money. So so he had money to pay for expenses. So the question would be, was that framework fair that, you would leave that pot of $3,000 a month and then, split what was left over of whatever that was after the fact. And I thought that was a fair way of doing it, given that there was a problem of proof and also a problem with the accounting in this case. I'm sorry, I see that I've gone probably
No, you're fine.
well over, but I think that was the way he decided to do it. And the only explanation I could come up with why, after the Here We Go ruling, why he didn't give an offset for that pot sum was because at that point, as of June 2019, he ordered the property sold, and Carrie was refusing.
Well, that
to sell it.
would be another reason to say, well, yeah, any expenses that happen after the Here We Go ruling are your fault, so I'm not going to give you credit for them, sort of out of equity. But he doesn't really say that either. right? That's not here in Romanet 5, is it? If it's somewhere else in the decision, maybe I missed it.
No, I mean, he mentions
He
that.
could have done that.
He mentions it in his contempt finding. He does make a finding that, after 2019, the reason that the property didn't sell for 2 years was entirely Carrie's fault. Carrie was to blame for that. My client was desperate to have it sold, and Carrie was the reason for the delay. I mean, I think it's a reasonable inference that,
Well, if he was gonna do that, he'd have to, account for the revenues that came in during that time period that wouldn't have come in if it sold early either, right? There are pros and cons to not selling.
Sure, I see where you're going,
yeah.
but, I mean, I think the expenses were minimal. If we are going to remand on this, I would ask that the court keep it. I mean, obviously, it's limited to that time frame, and then just to these, expenses that, counsel lists in her, in her briefing, which would be the hard expenses for like insurance and bond.
I mean, but correct, maybe you're gonna push back on what I'm about to say, but I wanna make sure I've got the contours of it right. I think they're telling us it's not limited to those three that are identified on page 20, whatever, of the brief that we were looking at. I think what they're saying is, because the court has this sort of fundamental error up front about the effect of the stipulation, that it might go beyond those particular ones, but the court's gotta figure that out. Do I have that right?
I mean, I don't think they're asking for an entire redo of this, and that's apparent from the fact that there's a concession that we're not appealing any of these other expenses.
But the net of that would be the things we've listed that we're not appealing, that has been decided. On remand, I think they're saying everything else is still in play.
Just the limited ones for those, that 17-month.
Yeah, for
Right.
that, for that,
Period.
win-
We're
for that
not going
window.
to-
Time period, the window, but not,
Right, and it would be limited to,
Yeah.
to the hard expenses. I would ask that if you would do that. I mean, I think that the trial court's going off of the stipulation made sense, in the sense that, Carrie, as manager of the business, would know what a reasonable expenses were to predict what should have gone into that pot, but,
So if we do remand this, who's getting it? Anybody know? With Judge Skanky off covering calendars in West Jordan and enjoying retirement.
I haven't looked.
You guys would have to start from scratch with somebody else on this, so.
not me.
All right, I have a couple questions for you on this last issue, and then we'll let you go. So the payment that Carrie says was made on June 30th of 2020, that payment was made, right? I mean, when we go look at the underlying documents there, that payment was made, even according to your own client's exhibit, right?
that's correct. I'm not going to make a fuss about that.
So do you have a problem then? I mean, at some level, it makes sense that we'd go ahead and correct it, but that feels a little fact-finding-y, which is not a thing that we normally do. But if you're agreeing that the facts show that payment was made, to use the verb you just used, are you going to fuss if we issue a ruling saying no?
I mean, it's been liquidated. You have a number.
So
If you're gonna remand on this issue, I would prefer you remand and say, add the 7,500, if you're gonna do that.
well, let me ask you this way, and maybe you just answered it, but do you still regard this as a contested fact? Or do you regard it as a fact for which there's only one version?
I mean, it's, her exhibit shows the same payment that is missing that
Yeah, I
it
mean,
does. So
right,
I
if
think we're gonna
everybody
have a hard
agrees-
time
Right.
on that,
If
so
everybody agrees that payment was made, then I don't know that we need to have a
yeah.
new judge fuss around with that.
If
Like,
you're
I
gonna
guess we
just-
could remand with directions to,
Yeah.
If you're
But
gonna do that, just do
The
for
other
the
issue, the
75.
payment that may or may not have been made on March 1st of 2021, what's your position on that
I
one?
mean, I think that there was sufficient evidence in the record to support it. There was testimony in our exhibit, and that's a disputed issue, so the question would be, is there enough evidence in the record to support it? And there was, so the trial court can't be said to have abused its
Yeah, I mean, what they're
discretion.
making on that is a sufficiency challenge, and so it's not an adequacy of findings challenge, as I understand it. I think it's a sufficiency challenge, so what we're looking for is there evidence in the record to support that finding? And your position is, well, there's conflicting evidence on it, so there is.
Right, and so, I mean,
Yeah.
like I said, I get that the exhibit is what it is, it's maybe a math error, But the other is the sufficiency of the evidence. So
Okay.
there's enough evidence in the record to support it. See that my time is
Great.
way over. Thank you, Your Honors.
Thank you.
Thank you. Ms. Nelson?
I want to talk first about the Romanet 5 issue. I am limiting the argument to Romanet 5. I'm sorry the brief wasn't clear. That's what we were going for. On remand, we know that the trial court came up with a number, $171,003.71. It's not, I don't think that it would be appropriate to only limit it from November forward, but going the full distance is really, really easy because we know exactly how much was held back. So for all those months beforehand. So we've got $171,003.71 of expenses. We figure out how much was held back. We figure out if all of the things that add up, I mean, I think we've already got a finding saying that the $171,003.71 is legitimate. So we just need to figure out what the reconciliation.
Certainly a new judge is going to want to grab onto that number, right?
Sure, right, sure, and they should, right? You've got a factual finding that those were legitimate expenses, and they haven't ever contested that they weren't legitimate expenses. And as you pointed out, he didn't give any other reason for why that was not right. So we can figure out how much was held back, subtract, there you go. That's all I would ask to do. I would ask for the remand not to be limited to November going forward. As to the Bell Canyon, so when we are looking at the ultimate reconciliation, this is important. We go to 2457, we've got amounts due to petitioner, we've got a Bell Canyon amount, we've got all of these additions. I would ask that if you affirm on the Bell Canyon issue, you clarify that on page 2458, if those numbers are not right, then they need to be, the offset needs to be dealt with equally. And if the numbers are not right because the 98,000 actually should be something different, then it's gonna change what the bottom line numbers are. The trial court subtracted that from how much it thought was in the account. And so it's subtracted to the penny in the middle of page 20.
Are you saying you think it makes a difference somehow if those two numbers are not 98,792, but instead are 13,000?
Well, it's going, sure, because the bottom line numbers are going to be different, right? I mean, like, on page 2457, if the 98,792 number is actually 13,000, then the subtotal due to petitioner is also going to change.
Yeah, but the other subtotal due to respondent is also going to.
That's right. No, I
So
understand.
explain to me how that would come out differently.
Well, I'm just saying that in the next reconciliation, in the next paragraph, the combined total due to both parties is this, which is $25,225.17 over the Bell Canyon net sale price. So the court then split the difference equally. But if that's actually not if those numbers that on page, in the middle of page 20, petitioner is entitled to 557,088.37 minus 12,000, she gets 55,44,757.90. But those numbers are actually inflated because the 98s should have been 13s. Those numbers are gonna be different. So it's just would be important to split any difference equally, which is what the trial court had done here.
So are you saying that one way we can resolve this is to tell the district court that it sort of got the concepts wrong and then let the district court redo the math?
Well,
Is that what I'm getting?
you may have to do that. And it may turn out that they still get, I mean, this is an imaginary number, right? The amount that they're due is an imaginary number because that Monex number wasn't right. That Monex number, there isn't actually $98,000 each to split. So you've got an imaginary number here. So you're gonna have to, I mean, if that's the conclusion that you reach, then the reconciliation in the end is also gonna have to account for that.
But then going to the question that Judge Harris has been asking, aren't we in harmlessness territory then? If
Sure, but-
we're just moving the number to different buckets, but we're at the same place, why would we send it back to the district court to correct a math error that's not going to change the ultimate number?
Well, I understand that's what he's saying, and what I'm saying is eventually both of these people should be entitled to their money. Like, we should actually go to the bank and divide out what the money is and give it to
I
them.
mean, I can go back to Chambers in 10 minutes.
Yeah, and do the math,
And
right.
run that calculation with 13s in there instead of 98s in there and see if it makes a difference. And if it does, then maybe we would have to send it back and have the trial court redo that. But if it doesn't, if it comes out in the wash in the middle of page 20, in other words, because both sides' numbers are going down, then maybe we wouldn't. I don't know.
Right.
But I don't know that any of us knows the answer to that question as we sit here right now, do we?
We're gonna have to actually do the math.
Yeah.
Yeah. Thank you.
All right, we appreciate your briefing and your arguments today. You have answered our questions.
It was a well-briefed case on both ends, thank you.
And well argued.
I want to plug that. The briefing on both ends was very helpful.
And we'll take it under advisement and issue an opinion in due course. Have a good day.
All right.